This December 2013 India Today cover best captured the anger and betrayal sexual minorities in India felt following the Supreme Court judgment that made being homosexual a crime again. Celebrated writer Vikram Seth, seen here, wrote, "Of all the cruelties that we as human beings can visit on one another, one of the most cruel is to say, 'You shall not love or make love with the person you love, not because of excessive youth or because of unwillingness, but because he or she comes from a different religion, a different caste, the same village, the same gender.'" Seth also pointed out to those who lauded him for his stance, "There is nothing heroic in doing what I have done. There are gay people who live lives of quiet desperation in India's towns and villages. They are bullied by their families and relatives." That judgment by the Supreme Court is an appeal, and the Constitution Bench of the Apex Court will today begin hearing the challenge to Section 377 of the Indian Penal Code that criminalises homosexuality. First, what is Section 377 of the IPC? Section 377 is a British-era law enacted in the 1860s that criminalises so-called sex against the order of nature, or in other words, it even makes consensual gay sex criminal. Essentially, what two consenting adults do in the privacy of their homes is under state scrutiny. Let's look at how the courts have viewed the matter. In the year 2000, the Law Commission in its report recommended that Section 377 be deleted. The Commission was of the opinion that consensual sex between adults, whether of a heterosexual or homosexual nature, should not be penalized, unless, of course, it was non-consensual. Remember, those who've been vocal advocates of retaining the section often state the necessity of this provision to deal with the sexual assault of minor boys. So, the Commission recommended that the law relating to sexual assault be made gender neutral, meaning non-consensual sexual acts committed on a person of the same gender also be covered under the rape law, which is to say that men and women can be charged with the rape of men, women and children. Of course, today there is a separate law, POCSO, that deals with child sexual abuse and rape. So what did the government do with the Law Commission recommendation? Nothing. We'll come to the role of elected politicians a little later. So, armed with the Law Commission report, a petition was filed in the Delhi High Court seeking that Section 377 be struck down. The petition stated that by criminalising private, consensual, same-sex conduct, Section 377 serves as the weapon for police abuse, detaining and questioning, extortion, harassment, forced sex, payment of hush money, and perpetuates negative and discriminatory beliefs towards same-sex relations and sexual minorities. In a landmark judgment in 2009, the Delhi High Court read down Section 377. Justice A.P. Shah, who authored the judgment, said, "In our view, Indian constitutional law does not permit that criminal law be held captive by popular misconceptions of who the LGBTs are. It cannot be forgotten that discrimination is the antithesis of equality, and it is the recognition of equality which will foster the dignity of every individual." The judgment declared that Section 377, insofar as it criminalizes consensual acts between adults in private, violates Article 21, 14, and 15 of the Constitution. The judgment was appealed in the Supreme Court. The petitioners included assorted religious groups. In 2013, in a judgment that was described by rights activists as having set us back by 100 years, the Supreme Court overturned the High Court judgment. In essence, the Supreme Court made being gay criminal again. Justifying its decision, it said, the High Court overlooked that a minuscule fraction of the country's population constitute lesbians, gays, bisexuals or transgenders, and in the last more than 150 years, less than 200 persons have been prosecuted for committing offence under Section 377, to which rights activists asked, is the constitutionality of a provision to be decided by the number of people affected? Furthermore, even when penal provisions are not enforced, the existence of that section in the statute books reduces gay men or women to what one author referred to as unapprehended felons, thus entrenching the stigma and encouraging discrimination. As a consequence, they're subject to harassment, blackmail, and extortion. The Supreme Court judgment also referred to Parliament's reluctance to do away with the law, saying, "This shows that Parliament, which is the representative body of the people of India, has not thought it proper to delete the provision." Again, this aspect has been dealt with in the Delhi High Court judgment, which spoke of popular morality versus constitutional morality. Moral indignation, it said, howsoever strong, is not a valid basis for overriding individuals' fundamental rights of dignity and privacy. In August 2017, hope floated again, in the form of a historic 9-judge bench verdict, now commonly known as the privacy verdict. The judgment declared privacy as intrinsic to life and liberty and an inherent right protected by the Constitution. The court held that sexual orientation is an essential attribute of privacy. Discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual. This judgment is likely to have a bearing on how the Supreme Court decides on the challenge to Section 377. Let's look at the big letdown by the legislature and the executive. The government of the day or subsequent ones could have acted on the Law Commission recommendation of 2000 and removed the offending section, but did not. Since public memory is short, let's remind you that the Congress party has not been a paragon of progressive values either. When the Delhi High Court was hearing the matter, the Health Ministry under the UPA took a view that Section 377 should be done away with, but the Home Ministry disagreed, describing homosexuality as a social vice and a reflection of a perverse mind. And finally, as the Supreme Court begins hearing the matter, let's hear it from the doctors. The Indian Psychiatric Society earlier this year launched its first ever campaign to assert that homosexuality is not an illness. This to dispel a belief in large sections of the public that mistakenly think of homosexuality as an illness that needs to be cured. In April this year, British Prime Minister Theresa May said she deeply regrets the role the United Kingdom has played in criminalising homosexual relations in its former colonies.
I am all too aware that these laws were often put in place by my own country. They were wrong then, and they are wrong now.
She's right. Section 377 of the Indian Penal Code was imposed by the British more than 150 years ago in India, a place known for accommodating sexual expressions of varying hues. World over, homosexuality is a punishable offence in 76 countries. While much of it was inspired by religious proscription, many of these laws were made and imposed under the British rule. In fact, of the 52 Commonwealth countries, or erstwhile British colonies, 36 still have laws that criminalise same-sex relations. Section 377 of the Indian Penal Code criminalises not just homosexuality, but any, quote, unnatural sexual activity. It was modelled on the Buggery Act of 1533 in England, instituted by Henry VIII, which carried the punishment of death for sodomy, a word derived from the biblical Sodom, a city of evil and excess. In England itself, homosexuality was decriminalised in 1967. So, when Indian outfits, religious or otherwise, decry homosexuality, they're only parroting the moral codes of 19th century Victorian England. Pride Month ended on June 30th, but UK's biggest gift for its LGBT community came in July with the announcement of a complete ban on conversion therapy. Prevalent across the world, conversion therapy includes methods employed by medical or pseudo-medical professionals to quote-unquote cure lesbian, gay or bisexual individuals of their sexual preference. These range from pseudo-psychological treatments to, in extreme cases, surgical interventions, even corrective rape as defined by the UK government. One of the most popular treatments remains shock therapy, where an individual is shown pictures of naked men and women with shocks accompanying pictures of the same gender. In one variation, the shock is replaced by apomorphine, a drug that induces nausea and diarrhea. The idea is that the individual will now associate the discomfort or pain with the same gender. Chemical castration, where gay men are administered estrogen to lower libido, something that World War II mathematician Alan Turing suffered through, also exists. Patrick Strudwick, LGBT editor of BuzzFeed UK, on an undercover mission, underwent conversion therapy and said, "The level of harm and damage done is beyond what you can possibly imagine. I ended up having neurological episodes." Conversion therapy is already completely banned in Brazil, Ecuador, Malta, and Canada. The move comes after a survey of over 1 lakh members of UK's LGBT community found that 7% had either undergone the therapy or had been offered it. The survey found that faith organizations like Catholic communities, which consider homosexuality a sin, were most likely to adopt the practice, but also highlighted that several people went voluntarily, actually believing there was something wrong with them. As UK Prime Minister Theresa May said, no one should ever have to hide who they are or who they love.